wasn't there Tuesday because I'm trying to spread this cold I've got, so give it to all of you.
Do what? I'm sorry?
Yeah.
Spread a cold.
Oh, okay.
I actually had a mask on at the doctor's office the other day, so I robbed a bank on the way home. What I'm very concerned about is the issue that came up about the tax exemption for the housing authority, because I feel strongly that you should have it, and I want to make sure we discussed it as thoroughly as we could. And I guess I should say we haven't. This is an open meeting. Well, thanks. And we have the open meetings laws over in the corner if anyone needs it for any reason. And I don't know that. I guess I'm running the meeting, so what I want to do is talk about the issue and hear from the assessor about what we think, what you think you need to do, and why, and then also from, I guess, the housing authority about what the basis of your claim is, if we could. I did speak to David Levy this morning, and he made it perfectly clear what ought to happen. So anyway.
Not that he doesn't have an interest.
Not that he doesn't have an interest, that's right. Well, Mike, would you mind telling us the philosophy behind what this is all about?
Sure. These are properties that are owned in a 99.99% way by a partnership which essentially is dominated by for-profit investors.
Right.
And the reason they invest in this low income housing tax credit property, the incentive is, and I've provided some materials, but the incentive is, and the gentleman representing HIO and OHA can step in anytime if I misspeak, but the incentive is in exchange for 10 years worth of tax credits, the investors provide money to help build the projects.
Right.
And so, for example, what I have provided to you is a list of materials. The first one represents, Mr. Hansen from OHA was kind enough to provide me one of these sample operating agreements. Okay, so the first one sets out the ownership structure. And HIO, Housing in Omaha, is a 0.01% owner. They are a wholly owned and controlled affiliate of OHA. So under this structure, the for-profit investor group owns 99.99% of these properties, and HIO owns 0.01% of these properties. Now, the argument is that these properties ought to qualify for exemption under a change to Nebraska law that occurred back in 2012. And at that time, the legislature specifically provided for an exemption for property that was beneficially owned for a political subdivision and used for a public purpose. There were also some requirements with respect to how large the value of that property could be, and potentially.
Do you have a site?
70. Yeah, it's in the. Yeah, it's 202. 70. What's that?
LB 902 2012.
Yeah, I think that's right. I provided in the fourth document I provided you is the codified version.
Okay, great. Oh, okay, I see it now.
Okay.
Thank you.
And the idea was to exempt properties that were created by political subdivisions through a type of facilities corporation that under SEC rules allowed them to do bonding. Okay? And so the requirement is the property must be beneficially owned for the political subdivision at the end of the lease purchase term, typically through a lease purchase agreement. At the end of the lease purchase term, the property goes to the political subdivision.
Mm-hmm. So the property, at the end of the term, the housing authority goes to.
They need, yes, they need to acquire title at the end of the term period.
The rest of the time.
Yeah.
Yeah, that's fair. There's also some provisions regarding a threshold value requirement and the necessity to go to the voters for approval under some circumstances. What has happened is HIO has applied, they have filed applications with us for exemption, and it's a little bit odd procedurally in the sense that If you're talking about governmentally owned, what generally happens is the governmental subdivision will provide us a list of their property, and then we have to make a determination of taxable or exempt. There isn't an application process for governmentally owned.
There's not.
No, they've gone ahead and applied as if they were a charitable, typical charitable, educational, religious cemetery, typical permissive exemption. And to be fair to Ohio, this is really an odd sock. There isn't much process to talk about what happens in terms of obtaining exemption for housing authorities or for wholly owned subsidiaries of housing authorities. There is a statute that provides if a wholly owned controlled affiliate of a housing authority owns the property and uses it for public housing, that qualifies for exemption. That's 71-1590. And we're not disputing that if Ohio actually owned the title, the property, held the title, they would qualify as long as it's being used for public housing. Now, what I also provided was, document 2 is from the operating agreement, a sample operating agreement provided by OHA that talks about what happens and their potential ability to purchase the property. What the operating agreement does, commissioners, is it provides them a right of first refusal to purchase the property at the end of what's called the compliance period. And for this low-income housing tax credit property, the credits span out over 10 years, but by law, to keep the credits or to have them not clawed back, the property has to be used for low-income housing for a longer period, a minimum of 15 years. Sometimes the land use restriction agreement involved in these properties is longer. Mr. Hanson, are these 15 years or are they longer? The ones we're talking about here.
Their public housing is longer. So there's one project where there's some low income tax credit units, and the other half is public housing. Public housing at least has to be kept public housing for according to the declaration of trust that HUD files on the property, and that's anywhere from 30 to 40 years.
Okay.
These other properties, I'll just add 2 of the projects at least, maybe the 3rd, but I haven't been able to find the formation document, were part of the Hawkins lawsuit, and those have to be kept public housing for 40 years.
Okay. But the point is, with this low-income housing tax credit type of project, it has to remain in public housing for at least or low-income housing for at least a minimum of 5 years after the 10-year tax credit period, or the credits are clawed back. So what I provide to you on page 2 of the materials is the right to purchase clause from the operating agreement. So they've got the right to purchase it, but it does not appear that the title transfers automatically. Document 3 is by contrast. That's a termination clause from one of these lease purchase agreements that the city of Omaha has with one of these facilities corporations. And that clause is much simpler. It just says at the end of the period, the property transfers title to the city of Omaha. Document 4, or the 4th item I've provided is, as we've mentioned, a copy of the statute that it appears housing in Omaha believes that they qualify for exemption under. And then the 5th document, or the 5th item, is a 3-page spreadsheet. And when we last met, there was some discussion of if the exemption isn't provided, these kinds of projects won't be done. NYFA provides the Nebraska Investment Finance Authority, which doles out credits, or assigns the credit. They provide us a spreadsheet periodically of all the LIHTC projects in Douglas County, because one of the things the industry has been involved in over the last decade is legislation to try and constrain or to specifically provide for a methodology for valuing those properties. They've been to the legislature several times over the years. And so in order to do what the statute requires when we value these properties, you kind of need to know what properties they are. And so if you take a look at the last spreadsheet, there's 3 pages worth of LIHTC projects. I think it works out to about 300 real estate parcels, which in turn represents approximately 721 buildings and about 5,000, a little north of 5,000 low-income housing
Would you say that again? I'm
units.
sorry.
Yeah, the spreadsheet, if you are nerdy and
I am
total up
nerdy.
the number of buildings and the number of units, it works out to about 721 buildings and a little over 5,000 low-income housing units. I just provide that as some perspective about what's the number that's out there. I had a colleague at the state that once said, if you exempt it, they will come. In this circumstance, I think if you provide the tax credits, they will come.
Yeah, no kidding.
This is not the first time we have encountered this issue. After the legislation passed, OHA came to us asking about, talking about exemption for this kind of arrangement. And way back when, we asked the Attorney General's office for an opinion. And they indicated to us in an opinion back in 2014 that they didn't think this arrangement qualified. It didn't qualify for a couple of reasons. One of them sort of related to this whole notion of the class of properties that could obtain the exemption were at least somewhat limited by this provision dealing with threshold amount and the ability to go to the voters to get approval if the project is big enough. Their stance seemed to be that since OHA can't go to the voters, this doesn't really apply to them in the same way it would a city or a county or some other political subdivision that can.
Do you know if the same kind of requirement going to voters, does that apply to funding for corporations in LD 775?
Well, of course it doesn't.
I'm sorry.
No, not in the
Okay,
least.
just wondered.
Not in the least. And then I think the second issue they pointed to was the idea that nothing in the new legislation changed 71-1590, which dealt with the housing and public housing authorities and their wholly owned and controlled affiliates, and that this situation would be better, I think, a better fit under 71-1590 once HIO owns the property, if they ever do. So, on balance, I mean, we're kind of sympathetic to the idea of low-income housing, but we just don't think, under the statute, the properties qualify.
Okay.
What if they own the reverse? Let's say the housing authority owned 99% of it.
Then clearly they would qualify.
Okay, so why wouldn't they almost say to themselves, big ideas on how to get the taxes, why not just have an understanding that at any time I can get a put for $1 and then have my 99% back?
Well, I don't know that, I guess I can't speak for the investing partners that own 99.99% of the building, or the buildings, but I don't know, does that imperil their tax credits? Does that, yeah, so.
It doesn't.
Which is why they need to
Okay.
maintain such a high ownership interest
I
in the
got
property
you.
environment
Okay.
under federal law.
So essentially you have a private owned entity that's a privately owned entity in order to obtain the incentives they're getting from the federal
Right.
tax code.
Got
Provide
it.
public benefit.
Teresa.
Teresa.
Well, that may be. What I will say is, in the sample agreement Mr. Hansen was kind enough to provide, it looked like the investment in that project was about, what, just less than $4.5 million. And I think the tax credits were just a little north of $4.9 million. So there's kind of a return on the investment at the sort of throughout the period because of the tax credits.
Before, Teresa, can I just ask you one thing? Who would benefit if we made this exemption? Who benefits?
Well, I think.
Is it the housing authority, or is it that investor that's getting the
The
tax?
housing.
Well, I think both.
It's,
Okay.
it is all the housing authority.
There's an affidavit that was written by OHA that kind of explains where the that it's approximately $95,000 in terms of property taxes would otherwise go back to operating expenses.
She reads everything for me. Go ahead.
Here's a copy for you.
Sure.
All right, so go ahead, Therese.
My question was simply, I wanted a clarification from Mr. Goodwillie. Commissioner Morgan had posed the reverse of the percentages, and you said it would qualify for an exemption, but are you stating it would qualify for an exemption under 71-1590?
Yes.
Based on the, okay, because there's a difference of which statute we're going under. And 71-1590 relates specifically to Public Housing Authority and says that it is exempt to the extent of the ownership and the use. If it's based on the ownership, so if you flip it and make it 99.9%, there's a specific provision that says, okay, based on the percentage and the use, then you would exempt it. You divide it and you do the percentage, yeah.
And in fact, over the years, Ohio has come to us when they have acquired ownership of properties and said, hey, we own this stuff, and we've exempted it.
Got it.
Let me ask a question about, and I'm a little esoteric about this, but has anybody read the legislative history? I mean, why did the legislature do this? I mean, I suspect, go ahead.
No, and I think your point in the lease purchase agreements, that seemed to be the focus. There were a couple different projects that the legislature looked at to say these were created, the financial structure underlying the project was done in a way to provide flexibility to local governments to create these entities without effectively putting it on the ballot. It's good or bad, it was a commonly used finance tool. The legislature took a broader perspective in looking at just lease purchase agreements. The context was, I think, a building in Norfolk, and then it was also a state one. But the legislature was a little bit broader. They focused on both lease purchase agreements, financing leases, or other instruments which provide for the transfer of legal title to the property to the political subdivision upon payments of all amounts due thereafter. And so they didn't want to hamstring, I think, local governments from creatively financing these projects in a way that, while not necessarily contemplated in the legislative history, would include these LIHTC projects. In order to get the capital that they need to build these properties, if the property ultimately returns to the political subdivision at the end of that period, that they would otherwise be entitled to a property tax exemption, provided there's a public purpose behind it. Public housing clearly falls within that category.
Well, and let me provide a little bit of additional local color. This all happened because one fine day the Department of Revenue got on the muscle a little bit, and there was a building in Norfolk that was owned by one of these development corporations and not owned by the city of Norfolk. And they said, hey, we think you're taxable. And so everybody marched down to the legislature and said, yeah, but the city of Norfolk gets it. They control this corporation. For all intents and purposes, it's a property that's used for a public purpose. So they added this additional provision to it. Oh, and that we don't feel we can do these kinds of projects if we can't issue the bonds when necessary. And the SEC requires one of these development corporations to be able to do the bonding. So the legislature said, bad Department of Revenue, and they added to the law what they added.
Well, for my money, I mean, I don't know, this may be a stretch, but I really, in thinking about this, there's a couple things I want to bring up. One of which is I really don't see, I do see somewhat of a parallel between what the OHA does with their investors and with what happens in TIF. The public policy is to, I think with the Housing Authority legislation, is to provide low-income housing, which I think is definitely a responsibility of all levels of government. So that's my opinion. And then with TIF, we take pieces of property that are, as they say, blighted, and freeze the valuation, and then a building like the First National Tower goes up, and then the revenue is diverted to the owners of the building.
Yeah, we don't freeze the value. We just
Well,
send the tax dollars to a different pocket.
That's what I mean, and the pocket is a private pocket.
Oh, I understand.
So I mean, you talk about it. I mean, I think and no one's questioning, TIF's arrangement. I mean, how much money was given? I hate to single them out, but how about Ameritrade? How much money did the Ameritrade get when TIF came down, you know.
The
I-
difference in taxes
Yeah, I
between
know
what's
it.
on the base and excess?
That was a big dollar
It's a
amount.
big
So, I mean,
hook, I have no idea.
I just think it's public policy. There are public policies involved here with TIF, which I fully support. I don't agree with the funding mechanism that comes from property taxes, but TIF is a great instrument. I wish they'd take the word blighted out of there, but anyway, it's a great instrument to build. It's fabulous. And I don't disagree with it. I mean, I think there's almost some unjust enrichment maybe at the other side of it where all this money pours in, but that's my opinion. The housing authority, same deal. There's public policy at stake here. This is a public policy that I think we all need to support and try to find a way to make it work. And lastly, I want to say, I remember a meeting with, and I'll defer to Teresa. Mary Ann Borgeson and I had a meeting with George Achilla and the former director of the housing authority, and Patrick was there, and I think maybe you were. You love this. Mary Ann and I got into a nice argument about, there's a statute that maybe this is what the statute is, I don't remember what it was, but there's a statute that I believe says that a county can waive taxation, public property taxes for a housing authority. And they came in, they said, we've got some difficulty, will you waive our property taxes? And Mary Ann's response was, well, what about us? And I said, what do you mean? Well, we have problems too. And I said, well, yeah, so we're suffering, so they should suffer too. So is there a statute, does anybody know about this statute? Do you remember that?
I don't think there was a statute that allowed that. I think they came in and asked whether the county board would allow either that type of situation or at least to not have to pay them as quickly, the property taxes
That was
back.
the issue.
And-
They knew they had to
and
pay
it
it, but they
was-
wanted to be able to pay them. I think
Yeah, because the
was one.
statute
Right.
I'm most familiar with is one that specifically
The opposite.
says that county boards can't waive or abate
Oh,
property
right.
taxes.
Right,
And in fact, if you do, you can be sued for the taxes you
Well,
waive.
let me cite my legal, let me cite my legal source for this. It's Rosanna Dana, never mind.
Okay.
I have a question.
Yeah, go ahead.
So is the operating provision here the right of to purchase at the end? If it said, like the cities do, that it automatically goes to the city at the end rather than the right to purchase it at the end, is that the difference in this whole conversation?
Let Teresa.
Teresa probably has some thoughts.
Go ahead, Teresa.
If I may, thank you. The property tax exemptions by case law have to be strictly construed. So the board should only consider what it can do via statute, what the statute allow. I would say there's an additional problem beyond just the right of first refusal. And the AG's office has pointed it out very aptly in their 2014 opinion, and it is this. If you look at Exhibit 4, which I think that's the statute that the assessor provided, 77202 in 1A1 talks about, letter B, property beneficially owned. The statute, if you go on to read it, tells us what kind of government entities could beneficially own a property. It says if a property to be beneficially owned by a governmental subdivision has a total acquisition cost that exceeds the threshold amount, and then it goes on to tell us if that happens, to qualify for the exemption, it only qualifies if they submit it to a vote. So it only works, the AG's office talks about it, only works for a subset of governmental subdivisions who have the ability to put a vote to the people. And the AG's opinion does go through and look at the legislative history in coming to that conclusion. So there's more than one problem that for 77202 than just the right of first refusal. That is a problem. But the other problem is, even if they amended their agreement to do an automatic reversion, do they fit into a subclass of political subdivisions that could put it to a vote of the people if they break the threshold amount? No. So does it apply to them? It doesn't look like it. And then the other thing that the AG's office talks about, which is very pertinent for the board, is if 77202 doesn't apply, it doesn't appear that it does, there is another statute that appears that it should, and that's the 711590. And there's a rule of statutory construction that a specific statute governs over the more general one. 711590 specifically talks about housing authorities, and it specifically talks about a housing authority that owns property with a non-governmental entity, which is exactly what we have here. And it says that if it's a combined ownership, then the exemption is only to the extent of the governmental ownership and the use as low-income housing.
Okay, so in your opinion, then, how does this get remedied so that the housing authority can continue to provide low-income housing without paying property taxes on the buildings? What do you think needs to be done?
I think a statutory change would be beneficial to them.
If I may.
Yes, please, I'd like to hear from you.
I think the argument in terms of whether or not the threshold limitation and bonding authority applies, you're talking about an either-or situation. One, it's either below the threshold and you're entitled to the exemption, or it's above the threshold and you have to put it to a public vote. I would draw a distinction there in terms of saying either or. This situation, this limitation cited by the AG's office doesn't apply in this particular circumstance. These properties don't meet that threshold requirement, and provided that they are otherwise transferring legal title to the local subdivision at the end of the day, they're entitled to the exemption. In terms of the specific versus general, I think in the context of 202, it's a much broader exemption, doesn't apply specifically to public housing, but rather creatively financed public purpose projects. And I would argue that you can draw a distinction there if you were so inclined to do so. I'd also point out, and Mike, you can correct me if this is wrong, but Department of Revenue promulgate regulations all the time. Strictly construed for purposes of property tax burden, however, the regulations do provide property tax exemptions may be allowed based on the inherent nature of the property ownership of the property and use of the property, or a combination thereof. So I would argue that you do have discretion as commissioners to otherwise provide this property tax exemption, if you were so inclined.
Thank you. Anyone else wish to comment on this?
Teresa, do you want to comment about that, or we can send it or?
I think I've made my comments. I think that the statutory rule of construction would apply, and the more specific statute would, it directly governs a joint ownership, not governmental, non-governmental.
Brian, you can correct me if I'm wrong. In terms of operation of these properties, the investors have no authority in terms of the direct operation of these properties.
No.
Counterpoint, it doesn't talk about operation, it talks about ownership in the statute. So.
Well, the next question is, does anybody have bail money? Oh. What's the alternative? I mean, so I mean, if it seems to me that if this came down where, as a practical matter, again, the parallel with TIF and other government's subsidies, and to encourage certain behavior, that if this, behavior suddenly says to these investors, this is not the deal, and, you're going to have to pay property taxes on these buildings all over the city. I mean, 721 buildings and 5,000 low-income housing units. I mean, it seems to me that the whole operation implodes and collapses. I mean, what happens? Teresa?
I wanted to ask a question of the assessor as a follow-up to that.
Okay.
You passed out exhibit number 5.
Yes.
And are these are properties that are currently engaging in this
Yes.
type of arrangement?
Yes,
And
they
are they taxed right now?
Yes.
So under the present tax
I couldn't hear
regime,
you.
Yes, they are.
They're
No,
taxed.
they're
They're
taxable.
Taxable.
So what you're saying is that if we do it for this, we'd have to do it for everybody on this list? Is that what
Well,
you're saying?
no, I don't think that's quite fair, because some of these don't necessarily have a public partnership component. What OHA and HIO are asking for are the pieces where they are this operating partner with 0.01% operating interest, and the investors own 99.9%. Some of those are purely investor-owned. There isn't an OHA piece. So
Well, how many, do you have any clue what percentage of this list would be directly affected by an action taken by the board to provide an exemption? Because that would be, I guess, just from a large perspective, my concern is anytime you take an action in a vacuum, you need to know what impact that would have in the larger context. And if you still want to do it, that's fine, but you should at least be educated into what the whole
Right.
picture is.
and there's
Right, but the point I'd make back to you is, hey, if it's the right thing to do, then we should do it and not look at the consequences
Right.
of what
Well,
it costs.
If it's the right thing to do,
However-
then do it for everybody. You need to know who else you're doing it for.
Right, but at the same time, if we're doing something that's proper by statute, then we should be doing it regardless of, hey, that's gonna be this much revenue that the county loses. if the statute provides we should be doing it, then we should do it legally. And if the statute is clear about us not doing this, then somebody needs to work at changing the legislation.
But in the meantime, if we remove this exemption, I don't think it's a free fall in this property. I mean, it's something that, you know, I know, I agree with what you're saying, except that if we say you're not tax exempt, then that we pull the rug out from under them, and until if it's corrected by the legislature, this whole thing's in a free fall.
Wouldn't they have known this going in though, the housing authority?
But they're paying the taxes.
Well, actually, some of these, at least from the sample agreement that Mr. Hanson gave us, they entered into these agreements even before the statutory change, a lot of them. So, you know, they've been operating under this taxable structure with tax credits, and then the law change occurred, you know, and now they're saying, hey, wait a minute, we think this new law should apply to us. To answer to somebody's question earlier, the 3-page spreadsheet 5 in the items I've provided, you get some clues. There's a column for management agent, which might give you some idea of which ones might be involved in a public-private partnership. I don't want to say for certain that that's the universe, but if you look down the list, typically you've got some of the usual suspects: NP Dodge, Byron Reed, Selden, and so forth. But then you run into some that are Douglas County Housing or OHA. So you do have some that have public partnership, but many of them are just completely private. The cynic in me says, if we grant the exemption today, it may not have an immediate impact on the majority of people on this list, but I imagine Mr. Hanson's phone will ring off the hook from developers that want to suddenly engage in a partnership with OHA or IO.
Is that bad?
To be able, I'm not saying it's good or bad, I'm just saying that's what's going to happen. And they'll build the properties and they'll come off the tax rolls. I'm not saying it's a good thing or a bad thing, I'm just saying I think that's going to be the reality of the market.
And I think that would be a great thing from a public policy
Yeah,
standpoint. More low-income housing, which there's a shortage in Omaha and statewide. And to the extent that you
Yep.
facilitate the development of those properties by granting a property tax exemption where they're otherwise entitled, and there is some ambiguity in terms of the statute and whether or not they're entitled to that property tax exemption, I think we can make a pretty compelling argument that they are otherwise entitled to that exemption.
I agree. And full disclosure, I was on the board of Holy Name Housing for 20 years, and I always none of their property is tax exempt. And even there's a Leo Vaughn Manor on Fountaindale Boulevard that houses, you know, retired nuns and all sorts of people and handicapped and otherwise, and it's fully taxed. Let me ask a question out here on the left-hand side, project name on the front page. It says Harney Street Apartments, 1115 Harney. I don't know if that's the one. But over to the right, maybe that's not it. But it says 48 units of handicapped and hearing impaired. Is that unit paying taxes?
I'm sorry, which ones are you?
Well, I'm looking at this one over here. It's got this 48 units of handicapped and hearing impaired.
Harney Street.
If you look under the project type.
I imagine, yeah, and I imagine it would be if it's owned by a private entity. I mean, ownership matters in these things.
Well, I know, but I agree with, you know, the public policy needs to be the deciding factor, in my opinion. Jim?
Teresa had something to add.
No, I think it's been addressed. Thank you, Commissioner. I appreciate it.
We don't want the mouthpiece to talk too often. Well, let me ask the Housing Authority, you know, what do you see as the solution to this, and what is it you would like to see come out of what we're going to do next Tuesday? What would you like to see, and what's your basis for it?
I'd like to see more public housing. That's
Yeah.
a good way to facilitate that. Talking relatively low, from a practical standpoint, we're talking about a relatively low impact overall. Political subdivisions turn to 95,000 for these properties that are ultimately going to revert back to the city.
I have one more quick question. Why doesn't the language just simply say that it automatically reverts back to was it Ohio?
Yeah, it's
Why
high
doesn't
up.
it just do it that way?
I don't know. That's how these LIHTC deals are just typically structured. I will say that these properties that we're discussing today were acquired by the Housing Authority around 2005, most of them, to settle the Hawkins lawsuit, which was a lawsuit where we had to provide additional public housing in Omaha. Housing in Omaha, Inc. loses money year after year. HUD continues to cut the subsidies that are provided to the Housing Authority. So we don't have enough money to keep up with our maintenance. We've cut our staff significantly. I'm not saying a property tax exemption on these properties would solve all of our problems, but when you look at the properties and what we're up against as far as deferred maintenance and staff restrictions, it would help.
Let me ask, what is the total valuation of the properties that we're talking about?
Well, let me first caution you. I don't know that, good, bad, or indifferent, the board ought to be making decisions based on how much money is.
So I'm just curious, because we give away so damn much money to all the corporations in the world. I'm just curious.
No.
You know, we give, I don't know, what TIF produced. You know, the city of Valley, from what I understand, 12% of its property taxes are locked up in TIF. So we don't hesitate when it comes to a corporation who wants to build something and say, please, make the walls of gold, we'll take care of you. So I'd just like to know what we're paying for the aluminum foil in these houses.
And I only mentioned to put it in context. That should not, I agree with you, that should not be said.
Because wherever this goes, wherever this goes, if the litigation piece of this goes beyond the County Board of Equalization, the appellant always has the standard to show that the board acted unreasonably and arbitrarily, and that has often come down to is if they decide based on factors other, than essentially the merits of whether somebody qualifies for exemption or not. And I think if there's all stuff spattered in the record that says, well, we can't do this because it's this much money, or we have to do this because it's this much money, I think that's unreasonable and arbitrary right off the bat. And so, but that said, because I'm really nerdy and don't have a lot to occupy my time, well, yeah, I do. But because I'm really nerdy, let me back that up. Is the properties on this list that are not the 3-page list I got you from NIFA, but the item E from the agenda a couple of weeks ago that has the Ohio properties that have applied for exemption.
You submitted an evaluation to us, didn't you? Didn't it disclose the evaluation?
I don't think that list did, to be real honest. But it's about $4.7 million just on the 3-page list that we provided on as item E on the August 2nd.
Well, the reason I ask that is I want to put this into context with what the subsidies are to other entities that are supported by the legislature to make people do good things, like TIF, and if they do these incentives, and this is what you get if you do this good thing. And so I'm just curious, because we have quite a bit of money invested in other actions that encourage people to build big buildings and make money. And I was just curious, as you may guess, I already favor the Housing Authority's position. So this is the amount of valuation, if it had been $20 million or $100,000, it doesn't make any difference to me, for the record. But anyone else have any comments to make on this? Do you care to say anything else? Anything else that needs to be, any ammunition you can give us? I mean, I think the point is that you're not rolling in money from this whole operation. That the money is not going, that it's going for operations, from what I understand. And so this is to keep the people in their homes. And a broader issue is, if this system collapses, it puts pressure on Douglas County, because we're the people who have to provide the social services, and that includes rent subsidies and housing and wherever else they go. So I don't know that, by saying to the Housing Authority, you don't get this, I don't think that helps the county at all. I think it just shifts the burden to the Department of Social Services, and it would frankly increase their budget dramatically. Well, we'll, you know, take the information we received today, and we're gonna talk about, and I appreciate everybody coming to talk this out, and I especially appreciate the assessor's office for the information that you've given us. It's very clear and knowledgeable. And Teresa, I thank you for your analysis as well. So I think if there's no other questions, the meeting will be adjourned, and we'll see you Tuesday. And I do have, if you park in the parking garage next door,